Welcome back to Democracy Undecided. This time we move from ballots to benches, from how Swiss citizens choose their leaders to how Swiss courts keep power in check. Switzerland is a civil law country, which means the rules that shape everyday life are written into codes and updated in public, not left to drift on decades of case law. That design choice sets the stage for everything that follows. Clear entry points like conciliation and OMBUDS services, simplified tracks for lower value claims, fee waivers, and legal aid where people need them the most. And the appellate courts that align practice across 26 cantons. And because institutions are only as credible as their outcomes, we read the system the way we read democracy, through evidence. Settlement ratio in tenancy and labor, average times to judgment in the federal courts, success rates on appeal, and top-tier international scores on rule of law and corruption control. Framed this way, the real question becomes simple. When citizens face corporations, and when both face the state, does the Swiss system reliably turn rights on paper into remedies in real life? Building on that frame, Switzerland's democracy is famous. Its justice system is the quiet engine that keeps the democracy believable. If the first episode showed how often citizens can say yes or no, this episode asks harder question. When people, companies, and governments collide, who actually wins? And how much does fairness cost? To answer that, we will look at the Switzerland's civil law foundations, its court structure, how fast and affordable justice really is, and which counterweights actually bite when the powerful overreach. To start at the roots, Switzerland is a civil law country. That means its core rules are written down in codes, not built case by case as in common law system. The Swiss Civil Code has been enforced since 1912, together with the Code of Obligations for Contracts and Companies and a nationwide Civil Procedure Code, CPC, has unified courtroom rules across all cantons since 2011. Crucially, these codes are not museum pieces, they are revised. A major CPC update entered into force on January 1, 2025. Explicitly to ease access to justice and speed up simpler cases. For example, conciliation authorities can now issue a proposed decision in money disputes up to 10,000 Swiss francs, and previously it was just 5. That's a small change with a big effect. More everyday dispute can end quickly, cheaply, and locally rather than grinding through full trials. With those foundations in view, moving from fundamentals to the machinery show how Switzerland's courts are layered to mirror its federalism. At the top sits the Federal Supreme Court in Lausanne and Lucerne. It isn't a second trial court, but the last word on whether the law was appealed correctly and applied correctly. Two specialized federal courts sit just beneath it. The Federal Administrative Court in St. Gallen, which hears appeals against federal agencies, and the Federal Criminal Court in Bellinzona. A federal patent court completes the quartet. Most trials still begin in the cantons, but the federal level is where the system's temperature is taken. In 2024, the Federal Administrative Court received 7,330 new cases and closed 7,144, with an average case length of 249 days, about 8 months. Meanwhile, the Federal Supreme Court decided 7,349 cases and allowed about 12.5% of complaints. An important indicator, most appeal fail, but a meaningful share succeed, including those that correct government errors or rein in private power. Because structure only matters if people can use it, access determines whether ordinary people can afford to use it. Here, Switzerland's blend of conciliation, cost rules, legal aid, and OMBUDS services matters more than courtroom drama. The 2025 CPC reform strengthened conciliation as the default first stop. In real life, you can see the effect most clearly in housing. In the first half of 2024, tenancy conciliation bodies across Switzerland handled 25,350 new cases. Nearly 60% of disputes were settled or otherwise resolved at the stage, and an extraordinary 86% of rent increase disputes ended in agreement. For tenants, that's fast and inexpensive compared with full litigation, and it's one reason Swiss landlord-tenant tensions are often diffused before they explode. In the same spirit, affordability also shows up in fees. Employment disputes up to 30,000 francs are exempt from court cost, and low-income parties can apply for legal aid. Pair that with the new power of conciliation authorities to propose decisions up to 10,000 francs, and you get a pipeline designed to keep everyday labor and consumer cases out of long, expensive fights. Switzerland also has a robust market for legal expenses insurance, which helps level resources between individuals and large counterparties. While coverage estimates vary, industry and survey snapshots indicate a significant share of households carry it, and the segment has been growing in recent years. To see how these levers work when it matters most, what really convinces viewers are moments when these gears move in public. Consider two private power stress tests. First, workers versus platforms. In 2022, the Federal Supreme Court confirmed that Uber drivers in Geneva are employees under Swiss law, not independent contractors. In practical terms, that pulled a multinational into the ordinary obligation of a local employer: social insurance, working conditions, protections, rather than letting the company stay in a gray zone. It's a classic example of a civil law courts using clearly statutory duties to rebalance bargaining power in a modern labor market. Next, the same design protects small contractors when invoices go unpaid by giant investors. After work is finished, a builder can quickly secure the debt with the builder's lien on the property, often on provisional basis, to stop the dispute from turning into the free loan. If the owner wants the lien off the title to keep financing or a sale on track, the court can lift it against a bond guarantee or cash security, so the project continues while the claim stays protected. Meanwhile, the merits are decided in the ordinary payment actions, with the statutory default interest adding up once the debtor is in delay, and simple debt enforcement steps press for the resolution. In practice, that sequence flips the leverage. Even a small subcontractor ends up secured against land or guarantee, while the court fixes the amount, which is exactly how a system turns formal rights into usable bargaining power. Then, citizens versus government shows the same balancing instinct through an external mirror. In April 2024, the European Court of Human Rights ruled against Switzerland in the Klimasenioren case, finding that the country's inadequate climate mitigation measures violated the applicant's rights, and critically that access to a Swiss court had been too restricted. Even though this judgment came from Strasbourg, it hit home. It told Bern that procedural gates cannot be slammed shut when the fundamental rights are at stake. Back in Switzerland, that kind of external nudge often prompts legal and procedural adjustments, part of a wider European ecosystem that keeps national justice honest. Finally, the state versus corporate management illustrate judicial review at work. In May 2025, Switzerland's Federal Administrative Court held that the federal government blanket cuts to variable pay for hundreds of former Credit Suisse managers were unlawful, emphasizing legal limits on executive bonus clawbacks after the bank's collapse. The government immediately appealed, and the issue moved to the Federal Supreme Court for a final word, illustrating the choreography. Urgent political action meets judicial review, and property rights meet public outrage under constitutional rules rather than slogans. Beyond headline cases, not all balance happens in courtrooms. Switzerland's ombuds institutions quietly resolve thousands of consumer disputes every year. In the telecommunications, the official ombuds body, Ombudscom, ran 781 conciliation procedures in 2023 out of 1,866 total contracts, evidence that many telecom quarrels never need a judge. In insurance, the private insurance ombudsman reported interventions that improved outcomes for consumers roughly two-thirds of the time. And in banking, the Swiss banking ombudsman said banks accepted 97% of its solution proposal in 2024 cases it formally intervened in. These mechanisms are inexpensive, fast, and available to people who could never afford a full lawsuit. One more way the system blunts the resources advantage of big players. Because speed is part of fairness, the numbers matters. We've already noted the federal administrative courts average 249-day case length and the Supreme Court's roughly 12.5% success rate on appeals. Put side by side, when tenancy conciliation settlement ratios around 60% and the new 10,000 francs decision proposal lane, you can see Switzerland's strategy: get easier disputes out early, reserves appellate benefit for points of principle, and keep the upper courts focused on law rather than fact-finding. It's not flashy, but in day-to-day justice, it's often better to be predictable than dramatic. To understand why that predictability endures, integrity undergirds the whole picture. On global measures, Switzerland sits amongst the cleanest and the most rule-bound jurisdictions. Transparency International 2024 CPI gives Switzerland a score of 81 out of 100, ranking 5th worldwide. And outside researchers summarizing the World Bank's governance indicator consistently place Switzerland in the very top percentile for rule of law and government effectiveness. Those are not trophies on a shelf, they translate into real-world odds, that contracts are enforced, officials are constrained, and court orders mean what they say. By the same token, Switzerland balances police power without doctrine of qualified immunity. If an officer's conduct in office causes unlawful harm, the claim is brought against the public body, the canton, the confederation, or the municipality, which pays damages under state liability rules and can seek recourse from the officer only in exceptional cases. Criminal accountability also remains open. Prosecutors can and do investigate alleged offenses, with a narrow authorization step in some jurisdiction for acts in office to ensure the gate is legal, not political. The point is simple. There is no blanket shield. Accountability runs through state liability, prosecutorial scrutiny, and judicial review. So victims have remedies while public services keep operating. Finally, openness must be lived, not promised. Courts hearings in Switzerland are public by default, and judgments are delivered in public too, unless a court articulates a concrete reason, privacy, safety, or public order, to close part of a session. Conciliation meetings, which resolve many everyday conflicts, are not public, because they are designed for candid settlement. Recording, however, is tightly controlled. Private audio or video is generally prohibited, with only brief discretionary filming or photography sometimes allowed at the opening or the pronouncement of judgment. Media access follows the same balance: open by principle, managed by permission. so the process remains visible without turning justice into a show. And to complete the integrity picture, the presumption of innocence is not a slogan here. It is a constitutional law. Swiss judges are required to start from innocence and to resolve insurmountable doubt in favor of the accused, a duty that tracks Europe's rights standards and applies across the criminal field. In plain terms, when the state accuses, the state carries the burden. The citizens does not have to prove they are blameless. Applied to taxes, the same idea splits into two lanes. In the assessment lane, the ordinary process of setting a tax bill, the burden is shared. Authorities must establish the facts that create or increase tax, while the taxpayer substantiates deductions or other facts that reduce it. If cooperation fails or books are unusable, the authority may estimate, and the taxpayer can rebut that estimates with evidence. In the sanctions lane, tax evasion penalties or tax fraud, the presumption of innocence fully governs. The state must prove the offense. And judges apply that in dubio pro reo standard because these are punitive charges. In short, everyday tax math relies on cooperation and proof from both sides. Punitive tax cases revert to criminal law protections, with the burden squarely on the state. For viewers coming from common law jurisdictions like Ontario, you'll notice another difference in Switzerland. Many who owes what questions are decided straight from the code, while in Ontario employment law, for example, the statutory floor, the ESA, the Employment Standard Act, coexists with a large body of judge-made reasonable notice doctrine, the Bardell factors. So your rights can swing considerably based on case law and contracts wording. In Switzerland, by contracts, the fee exemption for lower value labor claims and the one-stop conciliation stage are fixed levers written into national law. Neither model is better in the abstract, but the civil law approach is visibly designed to spare ordinary claimants the cost and uncertainty of finding their justice in litigation. Stepping back, what does all of this mean for how we measure justice in our quad-pillar prosperity metrics? First, we anchored the justice pillar in independent global database, rule of law World Bank, perceived corruption, CPI, and access to civil justice from WJP's factor scores, because they let us compare countries on a level field. Second, we add lived system ratios that capture how Swiss justice actually feels. Settlement share at conciliation around 59% overall in housing, 86% on rent increase disputes, average duration in federal courts around 249 days at the administrative court, Supreme Court allow rate around 13%, fee exemption threshold in labor less than 30,000 franc, and OMBUDS effectiveness, like, for example, 65% successful insurance intervention and around 97% banking proposal acceptance. Those numbers tell a coherent story. Switzerland's system is purpose-built to pull many disputes out of the courtroom, speed the rest through clear procedural lanes, and keep credible checks on both government and corporate power. To ground that story in concrete cross-checks, in international datasets that track institutional quality and integrity, Switzerland consistently sits amongst the global leaders. On the World Bank's Worldwide Governance Indicator, Switzerland scores extremely high for both the rule of law and the government effectiveness. Signal measures of how fairly courts work, how reliably contracts are enforced, and how well public services deliver. On Corruption Transparency International's latest index again places Switzerland near the very top among 180 countries. And in broader fragility benchmark, Switzerland ranks at the very best end of the spectrum on human rights and the rule of law. Together, these independent snapshots confirm what our case studies suggest. Access, fairness, and restraints are not just ideals in the Swiss justice systems, they are observable, repeatable outcomes. To make those numbers explicit, taken together, the cross-checks are unambiguous. On the World Bank's Worldwide Governance Indicator, Switzerland posts a rule of law score of 1.76 on the -2.5 to +2.5 scale, ranking fourth globally in 2023, while its government effectiveness stands even higher at 2.13, second in the world, signals that courts, contracts, enforcement, and public services work to a very high standard. In integrity terms, Transparency International's 2024 CPI, or Corruption Perception Index, scores Switzerland at 81 out of 100, fifth of the 180 countries, consistent with very low perceived or subjectively perceived public sector corruption. And on a system resilience, the Fund for Peace Fragile States Index gives Switzerland a 2024 score of 16.2, which is lower the better, one of the least fragile profiles worldwide. On the Index Human Rights and Rule of Law sub-indicator, Switzerland sits at the very top, 176th of 176, best in 2023, underscoring that rights protections and lawful administration are not just aspirations, but lived practice. Because our series needs one language for all pillars, we step back and ask, how do we actually measure justice and integrity in our quad-pillar prosperity metrics? As with democracy, we avoid single index shortcuts. Instead, we blend three independent data sets with a fourth lived system module. The external block captures institutional quality and integrity. The World Justice Project Civil Justice Factor, which is access, affordability, impartiality, and enforceability, the World Bank's Rule of Law score, contract, enforcement, courts, legal order, and Transparency International's Corruption Perception Index. We weigh those 40, 30, 15 respectively in percentage. The final 15% is a Swiss system performance module built from hard ratios we track inside country. Settlement share at conciliation, for example, 59% overall in housing and 86% on rent increase disputes. The free exemption floor in labor cases below 30,000 francs. Average time to judgment in the federal courts about 249 days. The federal Supreme Court's allow rate on appeals, roughly 12 to 13%. And OMBUDS effectiveness, for example, banking solution accepted in the vast majority of cases, with insurance interventions successful around 2/3 of the time. Everything is normalized to 0 to 100 scale and classified into tiers. 90 to 100 tier 1, 80 to 89 tier 2, 70 to 79 tier 3. Anything below 70 falls into the moderately prosperous band. Applying this methodology to Switzerland, we map WJP civil justice at 89 out of 100. Rule of law, WGI, at 97 out of 100. CPI at 81 out of 100. And the domestic system performance module at 92 out of 100, based on the settlement, duration, appeal success, and free relief ratios above. Rolled up with the stated weights, Switzerland justice and integrity composite lands around 90 to 91 out of 100, which places it firmly in tier 1 and makes it suitable as our benchmark for future comparisons. When we place this justice pillar into the quad-pillar prosperity metrics beside democracy, economy, and safety, Switzerland remains anchored in the highly prosperous category. In the episode 5, relevant to the Switzerland, we will integrate these justice results together with the democracy, economy, and safety pillars into a single comparable profile using the same ratios you've seen here to Switzerland's strengths, and any pressure points are visible at a glance. Returning to the citizen's eye view, ultimately, Swiss justice looks less like a single grand courtroom and more like a network of ramps, conciliation tables, cost waivers, legal aid gates, specialized federal benches, and ombuds offices that catch the small falls before they become big ones. In our series, this episode stands alongside democracy, economy, and safety. When we return in episode 5 to assemble Switzerland's full profile in the quad-pillar prosperity matrix, these justice metrics, law on the books and law in practice, will become the second anchor of the Swiss benchmark we use to compare every other country that follows. And to close the loop, by now the pattern should be clear. A codified, regularly updated body of law. Low friction on ramps that resolve many disputes before they harden. Discipline cost rules balanced by legal aid and fee relief where resources are unequal. Federal benches that correct errors and keep the map coherent, and a culture of written reasons, open statistics, and practical speed. The results show up in the numbers. We track high settlement shares at conciliation in housing and labor, predictable federal timelines, meaningful appellate wins, and consistently top-tier placement on global rule of law and integrity indices, alongside case-level signals that power is not above the rules. In the episode 5, we will fold these justice indicators, as I said, into our quad-pillar prosperity matrix, right beside democracy, economy, and safety, using the same ratios you've seen here: conciliation, settlement rates, free exam thresholds in employment, average time to judgment, appeal success shares, and ombuds effectiveness, to place Switzerland as our benchmark. When a system balances citizens and corporate power and keep the state inside the law, prosperity doesn't just grow, it becomes governable. This has been Democracy Undecided, Swiss-made justice. If you would like to keep learning with us, follow the links in the description for sources, datasets, and extras. Explore the other videos on our channel to stay educated. See you in the next episode.